SJC-13799, Commonwealth versus Brian Donovan.
Okay, Attorney O'Meara Costello, whenever you're ready, take your time.
Thank you. Good morning. My name's Ruth O'Meara Costello. I'm here representing Mr. Donovan. And I want to start by talking about the issue of the transfer hearing conducted in the juvenile court, and specifically about the question of whether counsel in that hearing was ineffective. The parties here agree that there's a right to counsel at a transfer hearing, which is an issue that this court hasn't previously explicitly decided. The dispute in the briefs is about whether transfer counsel herself was effective in this case. She was not. She made exactly 2 points: that Mr. Donovan did not have a record of this kind of offense, and that a lot of time had passed since the allegations. And they both were made in a passing way in the context of arguing forcefully for a continuance in order to allow her to fully prepare for the second issue.
You're not, all right, I know you suggest that the judge has a duty to tell the lawyer that they're going to consider both questions in the transfer statute.
I'm not sure that that's exactly what I suggested. I think that I don't think that that's what I've argued. I think I have argued first that counsel was ineffective, and so I think I'm pretty clearly assigning the fault to counsel. But that knowing that counsel was unprepared, I have said that the judge should have granted a continuance under those circumstances.
Why?
Because Mr. Donovan had a constitutional right to the assistance of counsel. There's language in Commonwealth v. Kavanaugh that where the court knows that
the judge should have bailed counsel out.
I think that, essentially, yes, Your Honor, the judge should have bailed counsel out because Mr. Donovan had no role whatsoever in his counsel being unprepared. I will say that I think that some judges do bifurcate the hearings. I think that it isn't completely crazy that counsel came in with that expectation, but I certainly think that she should not have been coming in unprepared. She should not have been coming in without clarifying what was going to be addressed at the hearing. And so I'm not, saying that her conduct was entirely reasonable, but it's Mr. Donovan's case in the end. He's the one who has now served a state prison sentence, and that might have been avoided if this hearing had gone a different way. And I think that counsel was saying—
If it had gone a different way, in what sense? That the additional evidence that you claim could have or should have been marshaled would have been presented?
So if the additional evidence had been marshaled, and I think we've shown that it could have been, this is not a case where there was nothing to say about Mr. Donovan as an adult. I think we've made a showing that that could have swayed the juvenile court not to—
Well, that's the part that I'm going to have the problem with, because if you look at the trial judge's decision, the two factors that the trial judge focused in on, in that the seriousness of the offense and the public interest in victim redress, she had already considered and credited that the social history favored dismissal. So when you say that I guess, because I'm now moving, if I'm going to assume for the sake of argument the deficient performance, I'm looking at prejudice now. So, that finding seems to really counter what you just said, that it would have made a difference at all as to whether or not she was going to transfer.
So I think, first of all, we're talking about a situation that didn't happen because the court didn't hear the additional evidence. And so there's some degree of speculation involved in talking about what would she have done if she had heard this evidence. What her decision actually says is she sort of lumps together two factors, social history and criminal history, and says, well, he doesn't have a criminal history, which is something that counsel was able to articulate, and then says there was no evidence presented about his social history, and so the factor overall favors the defendant. But I think that what we're really talking about is we're talking about weight on different sides of a scale here. We're talking about a situation in which the court is considering the public interest, including public safety, and making this extremely discretionary determination. And yes, the court weighs very heavily the seriousness of the crime. In general, the cases in which transfer hearings are held are overwhelmingly cases of late disclosed sexual assaults against children. And so the legislature has established this procedure to be used in those cases. It can't be that the end of the story is this is a serious crime, and so we don't need to hear about the individual defendant. I think, in fact, this court's past decisions have called for consideration of the specific crime and the particular defendant, and for a thoughtful presentation by defense counsel placing defendant into a developmental context.
He had no chance unless he's going to demonstrate how admirable his current, right? I mean, if he doesn't make a presentation that he's critical to the care of his, I can't remember, it's his father or his mother.
Father.
And, you know, and his girlfriend and their child, he's in real trouble because this is a terrible crime.
I think that's right.
And I mean, I read it. It's like a minute discussion. He's got no core. Basically, he hasn't been convicted of a crime or, you know, been arrested. That's the essential depiction of his personal growth.
That's right. And again, I think counsel is saying those things in the context of saying, I want to do a presentation at more length because, you know, but that's all that she's prepared to do at that moment. And
She's not even prepared. She isn't really prepared for much of that either. She just kind of basically says, I want a dangerousness evaluation and I have his Corey. That's it, right?
That's it, Your Honor. And I think that she...
But may I just press you on this? Because that's conflating two different things. So the issues about whether or not he's the primary caregiver of the father and all of this other stuff, that's not what we're talking about here. We're only talking about whether we're going to transfer this to the Superior Court. No one's going to transfer him to jail. This is just, you get to litigate it. The Commonwealth gets to try to prove their case in Superior Court.
But I think, Your Honor, that there are two parts to the hearing. One part is a probable cause determination, and that's not what we're contesting here. I'm not suggesting that counsel was ineffective at that portion of the hearing. Once the probable cause determination is made, there's a discretionary determination where...
You can look at his full development, right? It's not just whether he belongs in jail for bail. It's, is he living an admirable life and it's 30 years later? You can take that into account right under the two decisions we've written, JH and the one by Chief Justice Gantz.
That's right, Your Honor. I think that both JH and the 2020 matter of a juvenile case both emphasize the importance of specifically this second part of the hearing. And in matter of a juvenile, for example, where this court held that the defendant had to be competent before a transfer hearing was held. It was specifically in order for him to be able to give his counsel input into this exact set of issues about his adult development, his adult life. The cases talk about the factor of amenability to rehabilitation, which the juvenile court judge didn't address at all in this case, probably because there was no evidence about it presented to her in any way. I think that those are central questions that counsel should be presenting evidence on, and if it had been done here, as Your Honor, Justice Kafka pointed out, he's someone who was living a genuinely admirable life.
Do we have an actual affidavit from his, I know both people have died, right? So
Yes.
Is this sort of recreated from what? How do we know he's been doing this? Right, because they're both dead, right?
Yes, so both his girlfriend at the time and his father, who was, the father had Alzheimer's disease and may or may not have been meaningfully available as a witness. He was living at the time. His girlfriend, who was living with him and at the time of the hearing, living with him and his father, has also passed away. What I was able to recreate in doing the new trial motion was an affidavit from a neighbor who employed him to work as a gardener and was his close friend. And she,
Our knowledge about whether he's a good caretaker to his girlfriend and his father comes based on the neighbor's commentary?
in part on the neighbor's commentary, there is also the affidavit from transfer counsel who talks about knowing all of these facts at the time, and that at the time she had come to know Mr. Donovan very well. She thought that he was a wonderful, kind, empathetic person.
How does it work if we remand it as you suggest?
So I think that it has to be remanded in a new,
Right, but
a new transfer
but
hearing.
now we don't have the evidence.
I mean, I agree that that's a problem. I don't know that there's a way around doing the hearing, based on the evidence as it exists and can be recreated now. I think he would have been in a better position in 2017 to do it, but
So now you have the evaluation, essentially. That remains, right? You have the neighbor
yes.
and the evaluation.
you do have the evaluation. And I don't want to discount the neighbor's testimony either. I think that she, in fact, was his friend as well as his neighbor.
I just want to understand your position. So if we were to remand it, we have the evaluation, we have the neighbor. What else do we have? What else would the judge have?
So the judge would have his employer. He has, and I will say this isn't in the record because it's happened since, but he's been released from prison. He actually has gone back to his old employment at Dunkin' Donuts, and so he is again employed. I think that the employer gave an affidavit that we presented with the new trial motion. You would have an evaluation from Dr. Frank DiCataldo about his about Mr. Donovan's risk of recidivism. I think that counsel on remand would have to think about, now that he's been released from prison, what additional records are there? I think you would have records showing his good behavior in prison. I think you could, seek to talk to him about what his life is like now. Who are his social contacts now? Where is he living? I think that there's a whole world of things that you could do. CPCS has a practice manual that gives counsel a good deal of guidance about places that they might look for records, and I tried to do some of that work in the context of putting together the new trial motion, but of course time has passed and his circumstances have changed since then, and so I think it would be a task for counsel.
Can a transfer, a ruling on a transfer be appealed? That's my first question.
I believe that the rulings of this court are that it can be appealed after the Superior Court's decision, and so it's not...
So not before?
Yes, there's not an available interlocutory appeal from the transfer decision.
So the earliest it could be appealed is when?
I think
After a verdict in the subsequent trial?
That's right.
Because I'm having trouble sort of squaring that with the normal standard for a motion for new trial, because motion for new trial after the conviction seems to me one question in there is, is there a reason to disturb the conviction? And this doesn't really bear directly on that, right? This would be a weird form of collateral attack on that conviction.
I think that that's right. I think that it's, but that said, I think that, I think Rule 30 applies to it. I don't think that there's really an alternative to the defendant other than filing a new trial motion in the court in which he was convicted.
They couldn't have filed like a 211-3 after the ruling on the transfer?
I think that the past decisions of this court have essentially said that the remedy is a post-conviction
He could be acquitted in the Superior Court.
Exactly.
He could be acquitted in the Superior Court, but I think for anyone...
I'm speaking as a single justice. No, I'm sorry, Justice Walhouse.
No, that was my question, because that was my question.
And let me ask you about the mechanics, though, of your case as well. Another question on that. If this were to go back to the transfer judge, the transfer judge says, "Okay, I've heard the social history, and I still believe he should have been transferred." Then we have to reach your trial errors, or we have to reach your trial errors anyway. Because if the motion judge, transfer judge says I was wrong, the case is over. There's no conviction.
I do think that that's right. I mean, on behalf of Mr. Donovan, what I don't want is for the trial errors to get lost. So, you know, I think that it partly depends on how this court thinks that the Superior Court should approach a new trial motion under these circumstances where the Superior Court is not the court that, you know, the ineffective assistance incurred in front of. And so I know that Amici have suggested that maybe the correct thing to do is to ask the Superior Court judge to remand to the juvenile court judge to make a determination of whether counsel was ineffective. I would take the position that once there's a determination that counsel was ineffective, then the Superior Court verdict has to be overturned, has to be vacated because they didn't have valid jurisdiction.
Can I just to follow up on just because I'm getting a little confused. Say the judge says I was right. I've got this new information, and I was right. That's it. We don't have a new. Do we have a new trial? If we decide that counsel is ineffective for not pushing this, and then it goes back to the trial court on this issue, and they find that it doesn't matter, is he, there's not a retrial, right? Or what happens then?
Well, so I think that the question, I think the question is there an effective assistance, right? And so I think Your Honor is positing a situation where the judge looks at it and says, you know, this wasn't prejudicial, essentially.
That's what you were asking us to do.
I think that is what I'm asking you to do.
We would have an opinion, assuming we agree with you, that counsel was ineffective for being non-prepared for part 2 of the hearing. And then what? So that's my, sort of,
So-
then what? Then it goes back to the juvenile court to have a transfer hearing again?
So I think that once there's a determination made that counsel was ineffective, then I think that the Superior Court's verdict does have to be vacated because they did not, there was a constitutional defect in the transfer hearing, and they didn't have valid jurisdiction over the case.
No, who would
Why
make,
would it go back to the transfer judge to make a determination and
Why are we looking at prejudice?
relitigate that as you want? And then we could also reach the Superior Court judge errors, right? And if we find that it was a valid trial, then the conviction stands.
So I think that they're two separate issues. I think that if this court simply decides that counsel was ineffective, then I think that the remedy has to be that the Superior Court's verdict is vacated.
When you use the word ineffective, are you also subsuming the analysis of prejudice?
I am. Yes, I'm saying if this court finds that the Safarian standard fully is met, that counsel's performance was deficient and that prejudiced the defendant at that hearing, then at that point, I think that the Superior Court verdict can't stand.
Is there any case that, have we ever held that? Or has the appeals court ever held that?
I don't have a case to cite, to Your Honor. I would say, I would say that it's a jurisdictional question. I do think that this court obviously also has the alternative to, there was no evidentiary hearing held here. You know, I think that the court also could remand to the Superior Court with some set of directives about holding an evidentiary hearing or directing the juvenile court or asking the juvenile court to hold an evidentiary hearing. And I think that would affect what issues this court has to then reach and how they need to be dealt with.
Chief, could I follow up with one question? Of course. So, counsel, the question of whether or not transfer counsel was ineffective, you agree that our review is de novo?
Yes.
Okay. So let's talk about some of the things that happened, though, because we would still have, there's still a question to me as to whether or not the way that transfer counsel proceeded was tactical. So one of the things you filed with the record appendix is an affidavit from counsel who says that these cases proceed all the time in one hearing, right? So it's not a foregone conclusion that she should not have been aware that this was the case. And when I look at the procedural way that this went about, was waiting until jeopardy attaches, then pressing the motion to dismiss, it seems to suggest to me that counsel knew exactly what she was doing and that she thought that she was going to win on the probable cause determination and didn't prepare for the second part as a tactical matter. So if we have to look at all of this in the stew, how does that play out?
So I know what Your Honor is referring to. I will say I disagree very strongly that this was a tactical matter on her behalf, on her part. I think that she addresses in her affidavit the reasons that she thought that this was going to be.
Not really. She said, I talked to somebody. She doesn't say who she talked to. She didn't say what their experience was in these kinds of cases. At the time of this transfer hearing, she'd been practicing for 4 decades. So, you know, it wasn't really informed as to why that was a reasonable, why we should make an assumption that she really had no idea that this was going to proceed this way.
Well, Your Honor, I don't think it's an assumption. I think it is what the record supports. I do want to address that at the beginning of the transfer hearing, she did move to dismiss. And I agree with Your Honor that there's a sort of weird thing where she's suggesting that jeopardy attaches, which I think honestly, it was a completely, and I'm sorry to say this, but she made a completely legally incoherent motion to dismiss to start off that hearing. I don't believe that incoherent motion is any basis to say, and she strategically didn't prepare for the second half of the hearing. I mean, I credit her and credit her affidavit that she was confused about what was going to happen, and when you read the end of the transfer hearing where she's asking for the continuance, I think that she's genuinely shocked that things are going the way that they are and that she's not being given an opportunity. I also will say, you know, also in the record is an affidavit from attorney Sam Harold, who is an experienced attorney in these sort of cases, and I put that in the record largely to address kind of questions of what is normal in these hearings beyond what the statute says and when do they usually happen and under what circumstances. And he does validate that many judges do bifurcate the hearings. Again, I'm up here arguing that counsel was ineffective, so I'm not, you know, endorsing her full course of conduct. But I don't believe that there's a basis to find that her actions in not being prepared for the second part of the hearing were strategic. I do think that she thought, as a busy counsel, I can put off moving for funds for this evaluation that I want to have done because it only comes into play if probable cause is found, and if probable cause isn't found, then it's no issue. And I think, frankly, some judges have used the same kind of reasoning of bifurcating the hearing and doing probable cause first and then reaching the second set of issues only if necessary. I'm aware that I'm out of time, so thank you all.
Okay, Attorney Monahan.
Good morning. May it please the court, Assistant District Attorney Megan Monahan on behalf of the Commonwealth. The defendant's convictions for forcible rape of a child should be affirmed. Because the defendant's motion for a new trial did not raise a substantial issue, the defendant's motion was properly denied without an evidentiary hearing. Here, we have a Section 72A transfer hearing where the transfer judge heard testimony from the victim about the abuse inflicted upon him as a child.
No doubt they've explored the probable cause issue, the judges, but they don't do hardly anything on the other part of it, which is, I mean, we've said that you're supposed to really look at the defendant, right? Because there's just very little here. All we've got is he has no criminal record after this. That's what we got for her. And there's nothing more. There's nothing about whether he's still dangerous, and there's nothing about whether he's an admirable caretaker. There's none of that's here. I mean, shouldn't that have been presented? I don't know if it would be convincing given the severity of the crime, but shouldn't that have been done here?
No, Your Honor, I would suggest that all of the facts that were before the transfer judge are cumulative of the evidence that is in the motion for new trial.
The judge had none of the evidence that we currently have.
Your Honor, I would suggest the juvenile court judge, an experienced juvenile court jurist,
somehow knew that this defendant was taking care of his father,
Well,
knew that he was gainfully employed, somehow just got it from the ether? Or I'm confused because it's not shown in the record.
Your Honor, it's not on the record, but from the experience of juvenile court jurors, it is presumed, and this court has affirmed, the juvenile court has expertise and presumes to know the maturity and social
The judge
development.
can only do, despite being an expert, which I concede, what it can do given the record presented.
Well, Your Honor, I would, again, back to the expertise. That is why, despite any evidence on social history, that factor was found in the favor of discharge.
No, I didn't read that. Did you? I thought it said there was no social history presented.
It says no evidence was presented regarding defendant's social history.
Right.
As such, this factor would appear to favor discharge of the offense.
Referring to the no criminal record, which is the sentence before.
Well, I would, Your Honor, suggest that both go together.
But what social history was presented?
Your Honor, no social history was presented, but it was inferred, and the juvenile court found that factor in there. And if we would like to talk about the post-conviction evidence, suggesting the commendable, admirable, praiseworthy character as the defendant has characterized it, the Commonwealth would suggest this is just the normal part of growing up. It's the normal trajectory of maturity and development. He was
Isn't that
gainfully
development
employed.
something that should be considered at the transfer hearing? I thought that was what Part 2 really was about.
Well, Your Honor, Part 2, based on the standard of 72A, is the protection of the public and the public interest.
Right,
So it
and
is a
part
small
of that is considering the defendant's development since the time of the alleged crime.
And I would suggest that while it was not presented, based on the findings of the transfer judge, she found that in his favor. And so additional evidence, which just shows
But it's not a check the box type of thing, right? Where the judge has a lot of discretion to consider the crime and the person. But all he knows about the person is that he's not been convicted of a subsequent crime. That's all he knows about. And I mean, that may be enough, but it's not what we've envisioned, right? I mean, we've envisioned, especially this is a really serious crime. He has no chance unless he's presented the full picture of this person's maturation. And it seems like this is not what we had in mind here.
I understand, Your Honor, that it may be not what the court had in mind, or it may not even be the best practices. But, Your Honor, the question before us is whether counsel was ineffective and it fell manifestly below normal practice, and whether there was any prejudice here. And I would suggest, Your Honor, that those arguments covered the basis
How do you reconcile Di Cataldo's report?
Yes, Your Honor. I'm just going to take a moment just to pull it out. Your Honor, what I found very interesting about Dr. Di Cataldo's report, if you go to Record Appendix, Volume 1, page 37, these are the recommendations offered. Dr. Di Cataldo says that Mr. Donovan is at low risk for a future violent sexual offense, and as such does not need sex offender treatment. That, Your Honor, is based on the RSVP-2 analysis of a violent offense. Dr. Di Cataldo did not discuss or look at, in his final findings, the static 99R, which put him at an average risk of recommitting a sexual offense. And those factors that put him at an average risk are the same exact factors that the judge found in her adequate protection of the public prong, that the defendant abused a young boy who was a stranger to him, not previously known, and was an unrelated victim. So, Your Honor, looking at that report, it's swayed towards a low risk of violent sexual offense, but it actually comports with the judge's findings and concern.
To me, that's an excellent point, but to me, that sounds like that should be part of Di Cataldo's cross-examination.
Well, Your Honor, at this point, the question is whether a substantial issue was raised, and the Commonwealth's opposition drew the judge to all of those issues with the report, and the judge was not required to credit this report.
Can I ask you about the math going forward? Right.
I'm sorry?
The where the roads go. Okay.
Yes, Your Honor.
The conversation we were having with the council. If we disagree with you, the case gets remanded to Judge Sable, correct, for a proper hearing.
Your Honor, let me break that down in that I did disagree with counsel of that where ineffective assistance, we still have the prejudice prong, and this was denied,
Okay, so-
evidentiary hearing.
Right. So
The
suppose
Commonwealth,
we disagree with you and we think it should on the prejudice prong. Okay.
on the prejudice prong, thank you. So it would be remanded to this procedurally based on, I think it was the Commonwealth's last page, the footnote was a juvenile versus Commonwealth set out, a juvenile versus Commonwealth 380 Mass 552. It would be remanded to the Norfolk Superior Court judge on the motion for new trial with a directive for an evidentiary hearing in the juvenile court before the transfer judge, who is still sitting on the bench. I believe she's in another county at this point, but she's still sitting, so those evidence would go before her.
Okay, so then what happens with Judge Sable? If she says, I was wrong, haven't heard the personal history, the case is over, correct?
Procedurally, what would happen is that there would be a finding of discharge, and then I believe it would be a motion to vacate for lack of jurisdiction in the Norfolk Superior Court.
Right.
That would be the process again. But then if she does find, this was correct, then the conviction stands.
Right.
It's not a whole other process that we
And
need to
that,
go
which
through.
leads me to, that means we need to reach the alleged trial errors in this case, correct?
Your Honor, it's been raised in the motion for new trial and fully briefed. And so, yes, Your Honor, I was not imagining that it would be something that would be paused at this point.
Okay, thank you.
Can I just follow up on one piece of what you just answered to Justice Gaziano? On remand, is the inquiry limited to the point in time at which the original motion was made or the inquiry was made, or is it open to the judge to consider post-decision information?
Yes, Your Honor. Thank you for asking that question, because I was surprised to hear that evidence past 2017 would be heard, because this is a motion for new trial, and an evidentiary hearing would be what evidence was available that counsel could have provided in 2017. The Commonwealth would strongly object to any evidence post-transfer hearing being admitted at any evidentiary hearing.
Can I ask a follow-up again to Justice Gaziano's question? So if your sister argued that the Superior Court didn't have jurisdiction wouldn't have jurisdiction. So I'm trying to understand, if the transfer judge decides, and I don't know if Judge Sable decides on remand that the same thing, that the case can be transferred. Is it over, or your opposing counsel argues that the court never had jurisdiction because and she wasn't aware of any cases? But have we ever decided that issue? If we decide there's ineffective assistance of counsel at the first transfer hearing, and it shouldn't have gone forward without more an evidentiary hearing and more stuff, we can still affirm the Superior Court's trial decision if the transfer judge comes to the same conclusion. Any cases that say that? So,
Your Honor, I would direct the court, the Commonwealth's footnote 11 on page 54 cites to a juvenile versus Commonwealth 380 Mass 552 1980.
380 Mass, sorry,
552 1980. And that was remanded by the juvenile court, maintaining the convictions for further juvenile court proceedings. That was not an ineffective assistance of counsel case, but in finding that it should be remanded for further evidentiary hearing, that court cited to several federal cases, including, I don't have the cites right on me, but the names were Powell and Kemplin, and those were ineffective assistance of counsel cases that they did maintain the convictions while the juvenile court did further findings in evidentiary proceedings.
Was that the old transfer law or this one?
I believe
1980, or does it matter?
it does not matter. I believe, Your Honor, it was the analogous Section 61 transfer hearings, but where Section 72 has stayed throughout and the court has repeatedly used both, then I would say it has been a change in law.
I'm still confused. So what would this opinion look like? So are you saying that if we disagree with you and that there needs to be a remand to the juvenile court, we don't just kind of hold the trial issues in abeyance until figuring out whether or not Judge Sable comes to the same decision? Because these are issues that go to the conviction, right?
Yes, Your Honor, and I would suggest the court absolutely in their prerogative could hold it in the abeyance and just focus on the transfer issue and take it one step at a time. And I don't think there would be anything to prevent that if that would bring clarity to the opinion. I understand that both parties extensively briefed the transfer hearing proceedings. That being said, where it was the motion for new trial and the trial issues were raised and briefed, again, I think it's within the court's prerogative to also write that opinion, but I understand from judicial economy, if we need to deal with the transfer hearing first, that makes sense. That being said, the Commonwealth, of course, at this point would say the conviction should be affirmed. No substantial issue was raised on any point, including the trial issues. And Your Honor, just on my final points here is that the Commonwealth would really like to draw the attention to the inquiry of the 72A transfer hearing, and that the judge's thoughtful decision really balanced not just the protection of the public, which is what the defendant focuses on, but the public interest and victim redress. And I would suggest, Your Honors, this is not a tipping scales analysis, but if we look at the 5 factors that were found by the judge, 3 were in favor of transfer, 1 was in favor of discharge, and 1 was in favor of neither. Your Honor, this was a holistic view of the case, and where the defendant does not challenge the significant findings on public interest, the Commonwealth would suggest the defendant has not shown counsel was either ineffective or that better work would have led to discharge. If there are no further questions, the Commonwealth would rest on its brief.
Okay, thank you.